Hi, welcome back to my channel. Please like, comment, and subscribe. Maritime Law PLLC serves maritime injury victims all over the country, but the firm is proud to be licensed in Alaska, Washington, Oregon, New York, and Connecticut. If you are injured on the job in a shipyard, the first step is always to seek appropriate medical attention as soon as possible. Another highly important early step in the claims process is reporting your injury to your supervisor. It is best to do so as quickly as you can without sacrificing your immediate health needs. It is also prudent to ask for copies of any paperwork you see about the incident. If you are asked to fill out an accident report, be sincere, honest, and brief. Do not downplay your injuries and do not be afraid to directly state what negligence resulted in your injury. This includes referencing any rules that were violated, equipment that malfunctioned, co-workers that exercised poor judgment, and other entities that may have been involved. If you can, get some photos of the place you were injured and any equipment that may have been involved in the accidents. Shipyard employees can be exposed to all kinds of risks. Just to name a few: toxic fumes, falling in the water, slips and falls, forklift mishaps, tools and cargo dropping unexpectedly, crane accidents, welding injuries, falling from height. This and other unsafe conditions on the job in a shipyard can result in severe injuries. Common examples include head and neck injury, back and spine injury, hearing damage, ribs, tears, sprains and strains, amputations, broken bones, traumatic brain injuries. All too often, dangerous working conditions at a shipyard can result in the death of maritime employee. These outcomes were almost always avoidable with the use of proper care. You may be entitled to compensation under the Jones Act on seaworthiness and maintenance and cure. The Jones Act, also known as the Merchant Marine Act of 1920, protects U.S. maritime workers in the event of injury or illness while on the job. For compensation, a maritime worker must qualify as a seaman. The Jones Act requires a vessel owner to provide its seamen with a reasonably safe place to work and use ordinary care under the circumstances to maintain and keep the vessel in a reasonably safe condition. The Jones Act burden of proof has been said to be featherweight, meaning that almost any unsafe condition on a vessel, however small, may lead to liability for an injury under the Jones Act. Maritime Law PLLC can help you understand the various claims that may be available to you under the Jones Act, including pain and suffering claims, which may include physical and mental pain and suffering. Then, lost wage claims, which may include present lost wages, reduced future earning capacity, and loss of future earnings. Medical cost claims, which may include present expenses as well as anticipated future medical expenses. Then, wrongful death, which may provide a seaman's family with financial support such as lost wages, pain and suffering, medical expenses for the seaman prior to death, funeral expenses, and special costs associated with dependent children. The Jones Act is an important federal statute for mariners injured on the job. If you are a seaman injured in the course of your employment at sea, the Jones Act gives you the right to sue your employer for negligence. But what is negligence under the Jones Act? Simply stated, the Jones Act requires a maritime employer to provide seamen with a reasonably safe place to work. That means the employer must use care to maintain and keep its vessel in a reasonably safe condition under the circumstances. Jones Act negligence is a power claim. Unsafe condition on vessel, no matter how small, may result in liability against a maritime employer. Some unsafe conditions that may lead to a finding of negligence under the Jones Act include grease or oil on the deck, improperly maintained equipment, failure to provide the crew member with the proper equipment for them to do their work, failure to properly train the seamen or the crew, failure to require the crew to follow safe work methods. It is always best to speak with a seasoned admiralty lawyer about statutes of limitation for a Jones Act injury claim. However, the statute of limitations under the Jones Act is typically 3 years from the date of injury. You might be wondering, why is there a statute of limitation for Jones Act claims? Statutes of limitations are common under the law as time goes by, witness memories fade, and evidence deteriorates. This makes proving a case gradually more difficult for injured seamen, so when should you contact a maritime attorney after a workplace injury? As fast as possible. Unseaworthiness is a special legal concept under maritime law. The term may sound tired, but a vessel does not need to be taking on water in order to be considered unseaworthy. Unseaworthiness simply means that a vessel, its equipment, or its crew is not fit for its intended purpose. The duty of seaworthiness is owed by vessel owners and operators to mariners who qualify as seamen. The duty is non-delegable if a seaman is injured due to unseaworthy condition. He or she may be entitled to compensation under maritime law. However, only a seaman, a member of a commercial vessel's crew, can make a claim for unseaworthiness. Seaworthiness is a duty that covers the vessel from tip to stern. That includes heavy equipment, tools, appliances, engines, and crew. The doctrine does not require the entire vessel unseaworthy, nor does it mean that the vessel is in such bad shape that it cannot safely proceed on voyage. In fact, you may be surprised what qualifies as an unseaworthy condition. Some common examples are unqualified crew members, equipment beyond its working life, slick surfaces, improperly designed equipment, missing or broken rails, insufficient crew, malfunctioning equipment, lack of safety gear or safety equipment, untrained crew members, tripping hazard, long working hours, unsafe means of ingress and egress, unsafe means of operation, lack of supervision, inadequate safety procedures. If you were injured on the job, your world may be upside down right now. Hopefully, your employer is paying for your medical expenses and sending some checks to help with the bills. The best way to know if you are entitled to more compensation and benefits than what you are currently receiving is to contact a seasoned maritime lawyer. That is where Mariner Law PLLC comes in. A firm Jones Act lawyer can talk to you about the facts of your case and use knowledge of maritime personal injury law to help you understand what other opinions may be available. Mariner Law PLLC is licensed in Oregon, Washington, Alaska, New York, and Connecticut. but can be a great place to start no matter where you are. Maritime lawyer Adam Tate is pleased to assist shipyard injury victims with a free consultation call. Thank you so much for watching. Don't forget to like, comment, and subscribe.